has undertaken and continues to develop and implement. I'd like to thank my fellow judges, judicial officers, judiciary staff and members of the Judicial Service Commission, the public, our clients, the court users, our co-equal partners in government, Parliament and the executive, and all our partners and stakeholders for their continued support for the judiciary as we continue with our journey to improve the institution and sustain the transformation of the institution into a better, modernized, responsive judiciary that will deliver quality service to the people of Kenya. As always, it is my singular honor and privilege, my duty indeed, to invite the Honorable, the Chief Justice of the Republic of Kenya, to deliver some remarks and thereafter carry the program ahead. Thank you very much.
Your Excellency, President Uhuru Kenyatta, President of the Republic of Kenya and Commander-in-Chief of our Defense Forces, the Honorable Speaker of the National Assembly, Honorable Justice Muturi, the Speaker of the Senate, Honorable Kenneth Lusaka, the Deputy Chief Justice, my colleagues, the judges present here, Cabinet Secretaries present, ambassadors and the High Commissioners present, heads of agencies of the National Council on Administration of Justice, magistrates, distinguished guests, ladies and gentlemen, good morning. Let me take this opportunity to especially thank you, Your Excellency, for finding time out of your very busy schedule to grace this occasion. Your presence here, Your Excellency, is historic. You are the third president to visit the judiciary in independent Kenya. So we find this a very memorable occasion that you would find time to come and grace this occasion. I also wish to thank the honorable speakers of the National Assembly and the Senate for gracing this occasion. To me, your presence here today is a significant and welcome demonstration of the sense of amity that should characterize the relationship among the three arms of government. I also want to thank all of you, our visitors, for finding time to come and be with us during this official presentation of the 2016-2017 State of the Judiciary and Administration of Justice Report, SOJA. Please allow me, Your Excellency, briefly to talk about the State of the Judiciary and Administration of Justice Report, which we are launching today, and which covers the judiciary in the first part, and 21 agencies in the justice sector in the second part, before I revert to the significance of your presence here this morning. SOJA is a statutory requirement. It is prepared and presented in fulfillment of Section 5(2)(b) of the Judicial Service Act, which requires the Chief Justice to give an annual report to the nation on the state of the judiciary and administration of justice, have the report gazetted, and submit it to both houses of Parliament for debate and adoption. This duty is also in conformity with the national values and guiding principles of transparency and accountability in our Constitution. The report covers not only the activities of the judiciary, but also those of 21 other players in the justice sector as well, including the Office of the Attorney General, the police, the prison service, and the Office of the Director of Public Prosecutions, probation, the private sector, the Law Society of Kenya, and the civil society organizations. This edition, as the Registrar of the Judiciary has said, is the 6th since the start of the reporting and the first since I became the Chief Justice of the Republic of Kenya. It therefore captures the implementation of our new strategic plan, Sustaining Judiciary Transformation, a Service Delivery Agenda 2017-2021, which we launched in January this year. Your Excellency, ladies and gentlemen, I want to state that the state of the judiciary and the justice sector exhibits an emerging strength and numerous challenges notwithstanding. Our new strategy of sustaining judiciary transformation focuses on service delivery, a shift from the institutional capacity building approach of the highly successful judiciary transformation framework of 2012 to 2016, the strategic framework that was initiated and very ably implemented by my predecessor, former Chief Justice Dr. William Mutunga. Sustaining judiciary transformation is anchored on 5 thematic areas: enhancing access to justice, reduction of case backlog, enhanced integrity, accelerated digitization of the judiciary operations, and mainstreaming leadership and good governance. The report we launched today highlights our achievements as well as our challenges in the year that saw the judiciary and the justice sector in general make huge strides in service delivery. The judiciary has made tremendous progress in reducing case backlog in the last 6 years, drawing it down from an estimated 1 million cases in 2010 to just 300 cases which are backlogged today. Due to insufficiency in our judiciary, I'll read it again, that due to inefficiencies in our judiciary in the past and the very litigious nature of our population, our courts are still grappling with the high numbers of cases that should have been concluded long ago. As we reveal in the report, a total of 344,180 new cases were filed in the financial year 2016-2017. That, Your Excellency, tells you how litigious your people are, bringing the total caseload in the judiciary to 533,350. Of these, 63,214 are cases of 5 to 10 years, and we have embarked on an accelerated case clearance program to conclude all cases that are over 5 years by the end of next year. Your Excellency, ladies and gentlemen, one of the key objectives is to enhance access to justice by ensuring that court facilities are established close to the people. Under this strategic objective, we aim to establish at least one High Court station in each of the 47 counties as required by Section 12.1 of the High Court Organization and Administration Act. We already have established 39 High Court stations in 38 counties, meaning only 9 counties still remain without a High Court station. Makueni, Nyahururu, and Narok High Court stations were established during the reporting period. In addition, we aim to establish at least one magistrates court in each of the 290 sub-counties. Further, we have continued with the recruitment of more judges and other judiciary staff. Whereas at the start of the transformation journey in 2011, Kenya had only 53 judges. Today, the number, Your Excellency, stands at 160, with 28 having been appointed in the year under review. Let me add that our male-female gender ratios, Your Excellency, you know that is a serious issue. For judges, it's very good, standing at 60 to 40. For the entire judiciary, employees, it is almost in perfect parity at 52 to 48. Your Excellency, ladies and gentlemen, infrastructure has been a major plank in the judiciary transformation. During the financial year 2016-2017, court constructions in Bungoma, Garisen, Rongo, and Mpeketoni were all completed and handed over to the judiciary. Another 5 courts in Chuka, Kigumu, Engineer, Molo, and Makindu are complete and are awaiting handing over to the judiciary in the first quarter of next year. Your Excellency, ladies and gentlemen, as part of our service delivery agenda, we have, for example, started the implementation of a far-reaching digital strategy that will not only transform the way our courts work, but also how the public interacts with us. We are already piloting electronic case filing systems in some of our court stations, complete with the online assessment of court fees, and we hope to soon begin automatic transcription of court proceedings, as well as digitization of the registry and case management systems. This will not only speed up the hearing of cases, but will also help us maintain the integrity of the court records. One of the key planks in my sustaining judiciary transformation blueprint is the emphasis on individual accountability at every court station. Towards this end, we now require each court station to develop and display prominently in its premises its own service charter, aligned to the service delivery objectives elaborated in the Sustaining Judiciary Transformation Agenda. As part of our human resource development and management, we have introduced a performance appraisal system covering all employees. In June this year, we launched the first report of performance management and the measurement steering committee on the outcome of the evaluation of the first cycle of targets set in the financial year 2015-2016. After years of struggle and resistance, we are glad that during the reporting period, the first evaluation of what is popularly known as performance contracting was undertaken, and the well-performing courts were recognized and awarded certificates of excellency. We have also made some progress in transitioning tribunals from the executive to the judiciary in compliance with the Constitution 2010. The tribunals are already playing a major role in resolving disputes and clarifying the law. Indeed, our review of emerging jurisprudence in Kenya contains valuable contributions from these tribunals. It is the reason that this report has, for the first time, made tribunals, the case of tribunals are a full chapter in the report. During the year under review, 2 tribunals transited to the judiciary, bringing the total number of the tribunals now under the judiciary to 16. The Judicial Service Commission established the Tribunal Secretariat to coordinate the affairs of all the tribunals. The tribunals transition has far-reaching legal, administrative, and financial implications. To streamline this transition, we request Parliament to pass the draft Tribunals Bill and allocate additional resources to the judiciary to run the tribunals. Your Excellency, ladies and gentlemen, the judiciary continues to face the challenge of insufficient budget allocation, which has remained at an average of 1% of the national budget over the past 5 years. Indeed, this financial year, it slipped to 0.99%. This falls below the internationally recommended judiciary budget of 2.5% of the national budget. Given our establishment of 5,619, our presence in every part of the country where we sit every single day, and our people-focused transformation agenda, we need a significant increase in our budget allocation. In this respect, Your Excellency, we will be knocking your door and going to our Parliament to seek for funds to be able to do constructions around the country. I'm happy to note that the budgetary absorption levels have improved significantly, especially in the development vote, which previously had severe implementation challenges. In this financial year, we have now attained 67% absorption rate, up from 54% in the previous year. Your Excellency, ladies and gentlemen, the Constitution of Kenya envisages that the different agencies of government will continually interrelate and collaborate in various aspects of the administration of justice. During the period under review, there were many collaborative activities under the auspices of the National Council on Administration of Justice. The main ones being the assessment and preparation for the hearing of election petitions, implementation of the bail and the bond policy guidelines, that one, of the Court Users Committee, among others. Through the National Council for Administration of Justice, various stakeholders' interventions were put in place for better administration of justice. Among these were the legislations on children's matters and amendments to the Sexual Offences Act, implementation of the policies on bail and bond, reforms in the traffic sector, and the establishment of the business court users committees to engender investor confidence in our judicial system. A clear evidence of benefits collaboration in the justice sector is demonstrated by the report in the office of the DPP. The ODPP continued deeply to follow the money and the full range of the law approaches, resulting in more cases of economic crimes, abuse of office, money laundering, and organized crime. In that period, there is a total of 3,132 anti-corruption cases registered in the courts, with the ODPP recording an improved overall conviction rate of 72.4% in the financial year 2016-2017, which is the highest ever recorded in Kenya in this type of cases. Along with this was the introduction of alternative dispute resolution mechanisms, key among them being the court-annexed mediation project, in which disputes are settled through mediation by accredited mediators. The successful rollout of this project, Your Excellency, contributed significantly to Kenya's dramatic improvement in the World Bank's ease of doing business rating this year. Our country moved 12 places from position 92 to position 80. We are proud, Your Excellency, to be associated with that leap. Besides the determination through mediation of 93 cases in the commercial division of the High Court, that released close to 1.1 billion that had been tied up in litigation to the economy. The court annexed mediation continues to resolve many of these cases in the family division. And Your Excellency, we are emphasizing that cases like succession, the heirs, those are not matters that should be heard in court. Mediators can bring their family together and they share out whatever has been left by their deceased parent. Your Excellency, ladies and gentlemen, As I said at the beginning, the presence of all the three arms of government at this event is significant. First, it confirms that Your Excellency fully embraces the doctrine of separation of powers, and that although the three arms of government are independent, they are nonetheless interdependent. When any of them is discharging an important constitutional mandate, they do so in the knowledge that they are constitutional devices created to serve the same people. We do not have separate citizens of this country for the executive, for the judiciary, or legislature. We have citizens of the Republic of Kenya. Secondly, it shows that even though we may not always rule in favor of the government, this does not mean we are enemies. The high-minded doctrine of separation of powers and principles of the rule of law are sometimes necessarily inconvenient, but they need not be a basis for inter-branch friction. The government remains, Your Excellency, a major litigant in our courts, mainly as a defendant, but occasionally as a plaintiff. As far as the judiciary is concerned, the government comes to us just like any other party before court. And so we will continue ruling in favor of the government sometimes, and against it at other times, as guided by the law and the evidence that is placed before us. When the government has a good case, there is no reason whatsoever why we should not rule in its favor. But when the government has a bad case, or it bungles in its prosecution or defense, we should not be expected to rule in its favor. We want to assure you, Your Excellency, of the judiciary's commitment to work with the other arms of government and independent commissions to tackle the daunting challenges that confront our society. Top among these is, of course, corruption. It is my sincere belief that if the heads of the three arms of government resolve to fight corruption with unfaltering zeal, we will significantly reduce it, if not eliminate it altogether. We in the judiciary have our own challenges with corruption, which we continue to address within our human resource function, as well as through the Judicial Service Commission. While the vast majority of the judicial officers and the staff are honest and hard-working Kenyans, there are a few of us who are corrupt, we must admit, and we are catching up with them. As we report in this report, we have taken disciplinary action against 127 judicial officers and staff who are either on suspension or interdiction as we pursue our policy of zero tolerance to corruption. Your Excellency, all the agencies in the justice sector must stop the blame game. Wanjiku is not interested in knowing who is to blame for the dismissal of corruption cases brought to court. The business community and other investors are not interested in explanations about why it takes ages to resolve business disputes in our courts, holding billions of shillings, which should be released to spur economic development and create more job opportunities. They continue to demand for action. And the collaboration between the judiciary through the setting up of the anti-corruption division has brought accelerated speed of determining corruption cases, but also improved the conviction rate by the DPP. The report, Your Excellency, we are launching today has a lot more information on our activities as the judiciary as well as the justice sector agencies, but time does not allow me to highlight all of them. I want to urge the public to access the report from our website, read it, and give us written feedback. And in keeping with the provision of the Judicial Service Act, I want to announce that the report has been gazetted today, filed a gazette notice number 1244-8, and the official transmittal of, to both houses of Parliament for debate and adoption will also take place later today. I wish to thank the Judicial Service Commission, the judiciary leadership, and other justice sector institutions for their support. I want to acknowledge the immense contribution of the soldier preparatory team that the registrar asked here to stand under the leadership of Duncan Okello for working long hours to make this event a success. With those few remarks, Your Excellency, or are they many? It is now my singular pleasure to invite Your Excellency to address us. Your Excellency.